I'm Tom Goldstein. I'm the publisher of SCOTUSblog. I'm a Washington lawyer. I have a law firm called Goldstein and Russell. I teach Supreme Court litigation at Stanford and Harvard Law Schools. SCOTUSblog has been around for 10 years. It, like the clinics, is an outgrowth of the practice. We started it, my wife Amy and I, who practices with me, as actually an advertising tool for the practice. The original model for SCOTUSblog was we'll write about the highest profile Supreme Court cases. We'll also write a lot about what we're doing, and people, as a consequence, will want to hire us to do Supreme Court work. Turns out to be totally untrue. It is not an effective business development tool in that kind of direct way. It is in other ways that blogging in other kinds of practices can be. If you wanted to be a practitioner in a particular court of appeals or state Supreme Court, or if you wanted to do a particular kind of immigration or patent work, you could develop a kind of expertise that you would express through blogging that I think really could get you business. But in Supreme Court litigation, there's so many people who have such well-developed reputations. When you talk about Paul Clement and Carter Phillips and Seth Waxman and Maureen Mahoney and other folks like that, people tend not to say, I want the guy with the website, right? That's not what they're making their decisions based on. It's certainly the case that we become best known for the blog. As the blog has evolved, within about 4 or 5 of the 10 years, it really turned into a journalistic effort. And then all of the things that we were doing to try and advertise the law firm all were cast aside. And it went in the opposite direction because we really needed our readers to view us objectively and have them not believe that we were trying to kind of show off ourselves or highlight our own cases or clients. And we became sufficiently influential with respect to the court itself that we didn't want the justices and their law clerks to believe that we were trying to influence them in our cases. So we now have these policies that where I predict cases that will be granted, we always exclude our own cases. We don't write about our own cases. We get other people to write about them for us. We used to highlight briefs that we filed. We never do that anymore, where people of ours would get clerkships, all kinds of things to try and draw attention to ourselves. That's all now actually forbidden in the blog so that we can retain its journalistic objectivity. It generally works pretty well because the blog doesn't do a huge amount of commentary. It's not this Supreme Court decision was the greatest or the most horrible. It's describing what happened rather than evaluating what happened. So we don't find ourselves in a lot of dilemmas of not wanting to criticize the court or things like that. And if we do want to criticize the court, then we just do it. Although a lot of times we think the court does great work, and we sometimes say that too. And our commentary is generally done by third parties. We have these symposia, for example, on all the major subject matters: healthcare, Arizona immigration, coming next term, the Kia Bell case on corporate human rights violations, gay marriage, the Voting Rights Act, and hopefully the court is able to distinguish whatever those people say on the blog from what we might say as lawyers. It has been an extraordinary evolution for the blog, particularly as the amount of reliance and respect for the blog has grown. When the blog started in the early days of blogging, blogs were really regarded as kind of oddball things. And now you see a fair amount of respect for blogs that really show over the course of several years a level of expertise and balance. They get cited a lot in the traditional media. We get, a lot of people are saying very nice and kind things about us and rely on us. I'm not sure what the next major development for the blog is. Or for the past couple of years, the structure of the blog has been the same. That is, we adapted to the fact that people were relying on the blog essentially for 2 different kinds of things. One was, daily updates on what's going on, reports on oral arguments, and another was an archival research feature where they could get all of the briefs and could study the cases. And so we adapted the underlying architecture of the blog to accommodate that. We have case pages for all of the cases now. There's not and so I could see the path to this point. I haven't, in my thinking about the design of the blog, imagined the next big thing. I suppose it's likely to be multimedia related, to try and take advantage of, just the broadening bandwidth, the broader kinds of content that are there. The big project for the blog for the past couple of years has been improving the substance of what it is that we write, principally by getting better and better people to write. For years and years, we had the incredible good fortune that we had our students at Harvard and Stanford available to write analyses of the cases. And they worked really hard at it, and they did as well as students possibly could. But now we're in a position where we have really leading experts in the field doing the writing because of the prominence of the blog. And so now, the Harvard Law Review, which has 2,000 subscribers, we have, 50,000 people on our slowest day who are committed to taking the content of the blog. And, on the healthcare day, we had 2 million unique readers. And I think that a lot of people who are potential authors kind of recognize the blog now. And we just, we're very lucky in the kinds of people that we're able to get to write for us. Well, we don't really have a target audience as such, and that is, we don't have a vision for the kind of person that we're trying to reach. We recognize that for a long time, the principal people who were reading us were lawyers. Those are the folks who are most naturally fascinated in or have a utility for what's going into and coming out of the Supreme Court. But we've also recognized that as the readership of the blog has grown, we have a lot of people who have, a high school education. And so we've built out, for example, this plain English feature where we'll take all of the major decisions and we'll write them up at length in rhetoric that, an ordinary person can understand without a lot of the legal jargon. And in all of our write-ups, we have a plain English description at the end. So we're trying to accommodate the broadening readership of the blog. And we just view the blog as a public service. It doesn't have an agenda. It's not trying to impress any particular set of people anymore. It's not a business development tool for the law firm. And we just try and accommodate the kinds of folks who are becoming interested in the blog. Sure. Well, we actually are able to study our readership. One of the more formal ways we do that is through user surveys, but we can track all of our inbound readers unless someone takes the highly unusual step of hiding where they're coming from. And the Supreme Court doesn't hide itself. It has the IP address. Supreme Court of the United States is the domain that it is associated with the IP address. And we're able to see, hundreds and hundreds to thousands of hits coming in from them on any given day. And we know from our former students who are clerks, from just casual conversation with the justices, that the court is very conscious of the blog, and a lot of people inside the building read the blog. That doesn't mean that they think particularly highly of the blog or anything like that. Certainly I would never say that I think the blog has influenced anything that the court has done. But, if you're an important institution and there is one website devoted to following everything that you do, it's not surprising that you're going to read it. And I was concerned that the justices and their law clerks would come to believe that we were writing effectively to them. So that if we were so back in the day, for example, if we filed a cert petition, then we would write on the blog, we filed this really interesting cert petition, it's about this, that, or that question, here's the reason the court might take the case. That was never intended for the court as an audience, but the court doesn't know that and could misunderstand it. And so it became very important to cut all that out, because if the justices don't trust you, then you're not being an effective advocate. The other thing that happens is that because other people realize, or at least perceive, that the blog has an audience inside the building, people will try and use the blog to affect the justices. So constantly we're getting approached by people asking us to write about their cases, highlight their cases, cover cases in a particular way as part of their agenda for influencing the justices. And so we're incredibly resistant to that, both because we think it's improper and because we are just, we don't want the court to look at us in that way. A kind of prototypical illustration is there was a case last term on the merits at the court where the parties were trying to get, one of the parties was trying to get a set of documents in front of the court and was trying to lodge the documents in the court, but was unsuccessful in doing that. And so they couldn't get them in front of the justices and their law clerks in the ordinary process. And we got heavily lobbied to publish a story about the documents. And they were very interesting. And so it presented a really genuine journalistic dilemma about what to do, because it was apparent to me that a real part of their agenda was not because they wanted the documents published for the sake of publishing them in their interest, because they wanted a backdoor into the court. And we resolved that by not publishing them. But it was a puzzle to work through. Well, at this point, balancing our journalistic and lawyer roles is kind of the daily thing that concerns me the most, and that is I really want the blog to be a journalistic entity. And the lawyer piece of it is actually removing the relationship to the law firm and making sure that the blog can function purely journalistically as much as possible. The long-term dilemma and challenge that the blog faces is that the Supreme Court, though it uses the blog a lot, it refers a huge number of people to the blog, it relies very heavily on it. You know, it's much easier for the law clerks to call up the briefs through the blog than, you know, going through the clerk's office to get hard copies. The court doesn't recognize the blog as a journalistic institution and will not grant the blog a press pass. And so at the same time, they're not trying to stop us from covering the court. It's just a question of what you do with credentialing of blogs. It's something the court moves and changes very slowly. It hasn't figured out exactly what it wants to do in the situation. It relies on the Senate gallery and the White House credentialing process to make decisions. So we are nonetheless saved for the moment by the fact that the court still appreciates and respects and values the blog, and so it has credentialed our reporter, Lyle Denniston, as a result of the work that he does for WBUR, which is the NPR affiliate in Boston. And he does interviews with them and helps them out. And so that's the balance that the court has done. It tries to give us access to press-related materials through our reporter, Lyle Denniston. Now, Lyle is 82. And so at some point, he's going to stop doing this, though he's going, 200 miles an hour and does incredible work. At some point, he's going to decide he's done with it, and what will happen to us then is the long-term dilemma of the blog.